We're not making up stuff on people. When you're a writer, how do you get your work out?
I don't care what people think. I don't care what they say. They can say what they want to say about me. I don't care. I got the talent to write and I'm gonna keep on writing.
We decided that we couldn't try this in the court of law. We're trying this in the court of public opinion.
Just pay me what you owe me. We putting this out here so you guys can see.
This has given us closure. I'm gonna put it to bed after this. After I wrote this book in 2007, I decided that after seeing so many of Tyler Perry's plays, they had videos circulating the base with Tyler Perry's movies, but they were really just theatrical plays. And I said, wow, I heard that Tyler Perry in 2008 opened up a studio.
Nobody's safe. Nobody's safe. Nobody's safe.
During the case, since you were pro se litigants, did you, Terry Lowe, and William James feel threatened during the case?
Nobody's safe.
Of course I felt threatened.
Nobody's safe. Nobody's safe.
I had police
Nobody's safe.
stop bothering me. You know, I can pull off and get 10 feet from my house. They pull me over. And this actually had never happened. And diagonally sitting across the street was
Nobody's safe.
a police just sitting there watching. You know, they'd come and take my plates off the car and write me about 15 tickets. It was off the chain.
Wow.
Man, I'm telling you. And this happened, the same thing when me and you started fighting this case. The same thing was happening when I was fighting Tyler Perry over before.
My GPS kept routing me from the district court to the Tyler Perry Studios, the new one down in Atlanta. That's at the Army base.
Right.
It kept taking me to the front gate of Tyler Perry Studios.
I remember that.
How can someone do that to your phone? And then what happened was we realized someone, we don't know who, we can't say who, but we have an idea. We have a big idea, you know. People with a lot of money, whoever it is, you got to have a lot of money to do the kind of stuff that they were doing on our phones.
Right.
They kept hacking into our phones.
And computers.
And the computers. Remember, we had that where it said remoted in William James and then William James. Your name would show under my phone twice.
Right.
Once as the call I was on, and then it would be remoted in.
Right.
Someone remoted into my phone. And if you remote into my phone, that means you can change my GPS. So we're back. And now we're going over documents that are very important. We were talking about document 1, how everything in that document is so different from our prior cases because this is civil RICO. Civil RICO requires there has to be prior predicate acts that you were connected to in order even to bring a RICO case.
Mm-hmm.
Here, the result of presenting matters outside of the pleadings if on a motion 12B6 or 12C. So the matters outside of the pleading is our document 1, civil RICO. They're making a claim for copyright infringement. So that's a matter outside of the pleadings. It can't be this is the same merits as the last one, but yet you have to submit documents that are outside of the pleading that we presented in the case to try to make a claim. So it says if that happens and they're not excluded by the court, the motion must be treated as one for what?
Summary judgment.
Under Rule 56. And the certificate of service argument fails as a matter of law. And we show those laws and those arguments and that proof. And we show case law that shows that you have to ask for an extension if you're going to file an answer late, and you have to wait for the judge to respond. You just don't file an answer to the complaint when you're late.
Well, they could do that if they know what the judge is going to say already, if they're telling the judge what to say.
The Judge Story didn't get a chance to. So that leads us back to the stamped copy of our docket sheet. And we're going through this with you guys because we want you to see something here. So now we're going to move on up. We're moving up. We're going to go past this omnibus motion because this was a mess here as well. The defendants are still in default and they're filing answer to document 61, motion for judgment on the pleadings, judgment 58, 57, 41, 45, 53. You don't answer a motion for summary judgment with all of these things because it says according to their local rules of the court, it has to be responded to in a certain manner. So we're just going to go on up here to these illegally straggly looking things and look at this. See, this is locked on June 22nd. Submission to judge was terminated. Submission of what? Submission of any documents was terminated to Judge Story on June 22nd.
Right.
Then it says here that Judge Story reassigned the case and he is no longer assigned. But the judge was terminated. The submission to the judge was terminated. That means he terminated the judge behind the scenes and said, nope, you can't have none of those documents to rule on. Don't touch them. Reassign the case. And then the judge reassigned the civil action to Judge Thrash, signed by Richard Story. Okay, this is what I did. I went in here. This is our, okay, let me show you. This is our memorandum of law. See the name of this? Up top.
I see.
Preliminary statement, memorandum at law, omnibus motion. But that is, this document is missing from our motion. And it's not signed. And I think we argued that. Oh my God. When I'm telling you, going through this, it's showing so much mishmash. I mean,
look, do me a favor.
you can see this. Can you see this document?
Yeah, I see it. So why they got July 6th on the bottom?
Oh, let me see. I gotta open it up again. Because I went and closed it. I was so disgusted just now. Let me close everything. Let me go in here, reopen it. This is a nightmare, Bill. $81. Okay.
Okay, look. You see the stamp?
It says July 3rd, 2017.
Let me tell you why. Let me tell you why this is a phony sheet.
It ain't signed.
Look how they crossed out the date.
July 3rd, 2017.
July 6th.
But that say July 6th on it.
Right.
So how would they let me cross something out and not
So
sign
you
it?
didn't cross that out. Or did you? Is that you?
I don't recollect this. This doesn't even look familiar.
If you would have crossed that out, wouldn't you have signed it?
Of course. Why the other pages got July 3rd on them?
Right.
This is a mess. And so let's go back to the stamped. So document 81 was filed on July 3rd, but they're saying here that it was entered on July 5th. Can you see my screen?
Yeah.
Document 81, it says entered on July 5th, but how come it's stamped July 3rd?
That's my point. I'm trying to get you to see.
Just giving me a headache.
And then check this out. Now we entered that on July 3rd. Why take them 2 days to put it on the record?
Right.
Because they changed it.
Listen, if it would have been put on the record on July 5th, then it would have showed up with the submission to Judge Thrash on July 5th that was entered on July 5th.
Right.
It wouldn't have a document 81. It would have a different document number. So now here's where we said that we amended our complaint, right? This is our amendment, and it was entered on July 6th, but we filed it on July 5th, right? And it says, to proceed before a U.S. magistrate, modified 7/12/2017 to add parties. Please visit our website for pretrial instructions, which includes the consent to proceed before a U.S. magistrate, modified on 7/12. So they were trying to allow another judge to take it, a magistrate judge to take over the case, since we added Judge Thrash to the case. But that never happened. Judge Thrash was probably he's not going to let it happen. Because here's the documents that we filed as exhibits for document 85 on 86. We submitted it together, but they separated the two, which belonged together, fine by us, because this was our evidence. Notice of filing exhibits. Okay, so those were our exhibits. Let's see if we have those exhibits available for document 86. So, Lawless America, Corrupt Federal Judge. We filed this when we added the defendant Judge Thrash to our complaint as a defendant and co-conspirator.
That's that info we added too.
Document 86-3, it says corrupt federal judge Thomas W. Thrash dismisses Windsor declaratory judgment action. Judge Thomas Thrash has dismissed William Windsor's declaratory judgment that asked a Georgia state court to clarify that the state's power of attorney statute means. Judge Thrash, perhaps the biggest criminal in the ranks of the many corrupt federal judges in Georgia, dismissed the case while committing crimes left and right, violating numerous rules of civil procedure, ignoring the Code of Judicial Conduct, and obliterating Windsor's alleged rights under the Constitution and the Bill of Rights. Judge Thrash's order claims to be dated October 28, 2011, but it was not docketed until October 31st, 2011, which is the effective date. On October 17, 2011, Judge Thrash issued orders to show cause directing Windsor to respond in 14 days explaining why he should not be dismissed. On October 31st, 2011, Windsor filed his response to the order to show cause, but it was never docketed or processed. A courier hand-delivered the response to the order to show the cause with a cover letter. Miss Gutting, a deputy clerk of the Office of the Clerk of the Court of the United States District Court for the Northern District of Georgia, signed a receipt proving delivery. Delivery constitutes the filing. On October 31st, 2011, the clerk of the court entered the order dismissing the case, and the clerk entered a judgment. The docket on November 1st, 2011 does not show any of Windsor's filings on the case. So Judge Thrash ignored Windsor's motions for recusal. Among the reasons, Judge Thrash is a defendant in 2 Windsor lawsuits that charge a judge with criminal racketeering. Oh my goodness. Judge Thrash destroyed or otherwise concealed a number of Windsor's filings. Judge Thrash never issued an order based upon the facts of the law. All of this was done for the sole purpose of committing crimes of obstruction of justice and RICO, criminal racketeering. The single declaratory judgment action presents a good example of how the corruption works with Judge Thrash and the other federal judges in Georgia. So I am going to prepare an autonomy of a lawsuit to show every single thing that took place in the civil action, case number 111 CV 00922 TWT in the United States District Court for the Northern District of Georgia. I'll link all the proof and explain just what was done and the corrupt reasons for doing it. So we added the charges for him. Let's scroll down. I'm looking for the parties. Okay. So one of the things I noticed is that the parties is William James, is Terry Tucker, it's Oprah Winfrey, Lionsgate, and Barbara. I noticed that we're missing Judge Thrash in this document 85 altogether. You notice that? He's not number 18.
I don't even see.
His name is not even in here.
It applies to all of the defendants, right?
But how would he have known to answer? See, he was the number 9th defendant, but now it's missing. Remember how we said they were messing with our documents?
Right. Look,
we know we added Judge Thrash and his charges here.
Right.
I'm looking for Judge Thrash in the end. So I'm going down the cases. The only case that's down here that was added, I'm going to the cases. I'm just scrolling through the cases. These is 27 of them. So we want to get down to the bottom of them to see if there's anything new added about Judge Thrash.
So we really ain't talked about this document yet, right? But we talked about it.
No, we didn't at all. So I'm looking for the areas where we added Judge Thrash. That's what I'm trying to find. I don't see anything about Judge Thrash here. And I don't know how that could be possible if he answered the complaint and knew that it was amended, because when we amended it, we added him as a co-conspirator. Do you remember that?
Yeah, I remember that.
But why is it not in the complaint?
Maybe they
Okay.
modified it. Pull up the docket sheet and see if they
Here it is. They said we talked about William Windsor versus Judge William Duffy. Who they changed the name? This was done by Judge Thrash. The plaintiffs have been prejudiced in this same manner and believe it is in an effort to dismiss the case erroneously in favor or default or fail to defend defendants. The clerks of the courts are now interfering on behalf of the judge. Due to the number of lawsuits and numerous years from 1992 through the current, filed against the cartel ring.
Something is missing.
It's a lot missing. Because we actually called him, we gave him a label of co-conspirator. Because guess how we know it's missing? Because
scroll up for me just a little bit. Just a little bit. Scroll up for me.
Scroll up. Because they're all, I know it's not giving me the thing. It's not giving me the thing. PQR.
Wait a minute. Okay, go up a little bit more for me. Now we're missing something. Because the next one is 28. Which one is this one?
This is, we have to go all the way to A.
No, T.
Okay, so we got 24.
That's 24, right. 25.
So 24, 25.
26,
26.
28.
27. 27.
Right, now watch this. Keep going.
A, B, C, D. Oh, wow. A, B, C, D, C.
Right.
A, B, C.
Mm-hmm.
And then we got C again.
Mm-hmm. Keep scrolling.
A, B, C, C, D. Then we got E, F, G.
Mm-hmm.
H, I, 2 I's.
Right. Now you see what I'm talking about?
Yeah, they mess with our stuff.
Right.
J. Oh my goodness. K.
We back at K.
J, K, L, M, N, O, P, Q, R. And then it goes into
28. Now you see what I'm talking about?
Mm-hmm. Let's see if we see Judge Thrash's name anywhere else. They remember when we said document 85 was missing pages?
Yeah. It's missing a bunch of pages.
You know what I want to look at? Let's look at the pages again. You know how we know something's wrong? Because we had the pages different. Hold on. What? Hold on. Am I on 85? Okay. This one I want to look at. Page 2, page 3, page 4. Remember we have found the pages were wrong? 6, 7, 8, 9.
See, look.
That's 10.
I'm not going by these numbers. I'm going by the numbers that you put in there.
Yeah, me too. 11, 12, 13.
No, not them numbers.
I'm looking at the bottom. 14, 15, 16.
These are the numbers I'm going by.
Mm-hmm.
28.
Wait a minute.
29.
Now I see what you're talking about. We was at 27 up here, right?
Right.
And then we had 28.
Right.
And here. 29. 30,
Mm-hmm.
31, 32, 32.
Then you do A, B, C, 1, 2, 3, like that. And somehow at the top up there, that's when it all started getting jacked up.
You know what they did? This is what they did, Bill.
Not making sense.
It didn't make sense because they took our old appeal and just replaced it with what we had changed for our original appeal. So we had document 85. Let me look at the docket sheet. Where's that docket sheet at? Where we have, where is it? I know we had it open. I guess we closed it. So let me open up the docket sheet real quick because there's something here that's wrong. And I want to see something. Here, we can look at an earlier version of the docket sheet. So July 5th, 2017. Let's look at August. Let's see what August says on document 85. Going to document 85. Okay. So document 85, 86. Here it is. Do you notice how is it that 87 is after 88?
Right.
On July 6, 2017, 87. That's because we knew they went into 85 at some point.
Terry, this is what they did. Let me tell you. Look.
Because they modified it on July 12th. Look, they modified our complaint.
They modified.
Add the parties.
Yeah,
Look.
They modified it. That's
Here
what
it
they
is.
did. They modified it. Because technically, this was 7/05/2017, right?
You want me to find our original document 85 before we submitted it in the record?
Hold on. 7/6, 7/5.
But there's no way document number 88 is on July 6th and 87 is on July 7th. How are you going to do that? The numbers are backwards. It goes 88,
Right.
87,
That's what I'm
89.
talking about. See, that's why when we was going through it, I was like, no, that's not it. That's not it. Because it wasn't making sense to me. Because I was reading, it wasn't making sense. I was like, no. I knew something was wrong with it.
But there's no way for numbers to be backwards. And it'd be a day
83,
difference.
84, 85, 86, 88, 87, 89.
And 87 is on July 7th and 88 is on July 6th.
Right. Right. Which it should be the other way around.
It's because they had the docket open when they went in there to really go in and amend our complaint. They had the when they went on the record with document 87, they really went in there to modify document 85. But then they changed the date because see, it says it was entered on July 6th, the same day of document 88. Oh, look at it. Look at this. Let me show you. You see this? This is July 5th, right?
Right.
Document 85.
Right.
No, I ain't asked to leave. It's trying to make me leave. Right? The amended complaint. You see this?
Right.
So now,
You said the same thing at the bottom.
It says it was entered on July 6th, right?
Right.
This is July 5th, but they said they entered it on July 6th.
Right.
So let's go to July 6th. Here, they got on July 6th, document 88 filed on July 6th, but they claim it was entered on July 10th. But on July 7th, this should have been document 87. 88 should have been document 87. And this should have been document 88. But on July 6th, the same date that 88 got messed up, it should have been 87. They was up in here messing around with this document.
Yeah.
On the same day. Because look, it says July 6th. Down here at the bottom. Entered July 6th, document 85. And then they claiming this was entered on July 6th, document 88, but entered on July 10th. So what was you doing on the record July 6th?
A motion to strike, amended answer.
On July 6th, you was messing with this amended complaint.
Yes.
And here's my proof. You don't want to, let's look at our proof. I'm going to show you. Let's do this together, right? Let's go to, I want to share. Can you see me trying to go open up another document? You don't see me doing that?
Like it's stuck.
Do you see me doing a search?
Like your arrow is stuck.
Okay. So here I am. Okay. So let's search our amended complaint. So the date of this is 7/12. Let's see. We looking for this version that ain't been filed yet. So this is 7/12. That wouldn't be it, because we didn't file our amended complaint. We supposedly filed that on July 6th, right?
Right.
So that would be
It ain't up there.
You see this? How is this like this? Okay, wait a minute. Look, this one has 53. This one has 866 kilobytes.
Right.
Just look at it. Unreadable.
I can't even see it.
It says that it is unreadable and it is no longer there.
They jacked it. You didn't. Do the 717. This one here. Did I do that?
So this whole thing was a disappointment. How did you feel about the case overall? How do you feel?
I felt the overall case, I felt like we've been had. I felt like they cheated all the way through the case. I felt like we was betrayed by our own judicial system. It was like the judges were, it's like he was against us. The clerks was against us. A lot of
arguing and disrespect, right?
Yeah.
Do you remember that? How disrespected we felt? The way the clerks talked to us?
Yeah, they tried to get me to go against you that one time, remember?
Because that's why we never would talk on the phone without one another. Notice that?
Yeah, they were trying to get me to do something, sign something, or I said, hold on, please. I called you, you picked up the phone. I said, Tim, we need to talk to this lady. I knew you was gonna give it to her. you gave it to her too. It's like, oh, I can't do it. How you gonna call him and tell him to do this and do this and do that? You was getting it. Well, I said, yeah. I bet they won't try that no more.
I remember that.
You remember that?
Mm-hmm. Because you know what I remember about it? What I remember saying to her? I said to her, this is a federal court, right? And she was like, yeah, it's a federal court. I said, so that makes you a federal employee, right? She was like, yeah, I said, so under federal courts and federal employees, can you please provide us with the handbook or the regulation that says that you do not have to make corrections when you make an error on our documents on the docket?
Right.
And she was like, look, they're going to open up the document. They're going to see what's in the document and they'll know what it is. And we said, no, when you read the record, it does not say that.
Right. So that could have been no interest to them when they open up the document. Because if it's not saying what the motion is about, then sometimes there'd be no reason for them to open up the document, you know.
And do you remember the case in which it caused a huge problem? Not long after that, no, I think it was that actual scenario where document 101 was our permission to the court. That was our interlocutory appeal. The first appeal we did, I think it was 171329, whatever it is. And we was like, no, when we was in the appeals court, they put in a motion to dismiss our appeal, talking about we never asked the court for permission.
Right.
And we was like, we did. Document 101 is the permission. So we went and looked at the record on Pacer, and we was like, oh no, this is incorrect. So you was like, I'm gonna call him and I'm gonna get him to correct it. And the lady wouldn't do it. She was trying to get you to just do something like, right, something foo-foo it, like, ain't no big deal. And so you got me on the phone with her and I was like, you created a problem. I said, because you're not following your guides. If we could file for ourselves as electronic filers, then we would properly label.
We would have never had that problem.
No.
We wouldn't have go straight to the record.
They put duplicate appeal on there.
Yeah.
They put notice of appeal and notice of appeal on there.
Right.
So it looked like we had two notice of appeals.
Right.
And so they were trying to call our document 101, the defendants was saying, oh, 101 is their notice of appeal. They never asked for permission. So if you never asked for permission on our appeal, then it has to be dismissed because you can't file an appeal without permission from the court.
Right.
You just can't go around. So we was told that as long as you put that document in first, you can still just go ahead and file your notice of appeal, and the permission, whether or not the judge grants it, has nothing to do whether or not they accept it in the appeals court. It just has to be on the record for the judge to note whether he agrees or whether he doesn't agree with your appeal. So while we was on the phone with her, we was like, you caused a serious problem because now they could dismiss our appeal because you failed to label it as permission. I said,
that was their
open it up.
That was their plan.
Yeah.
But to get dismissed.
Yeah.
You know, especially the judge. Well, we had the worst judge in the world. He was.
Well, at that time, it shouldn't have been that judge because we had a different judge. Right. And these were the problems of the case. This is what we talking about. Like, we started off with Richard's story.
Right.
He was doing what he was supposed to be doing on the record. And then behind the scenes, it says, terminate the submissions to him. So he was terminated. He didn't ask to get off.
Right. He didn't resign off the case. He
didn't resign off the case. Yeah. But they had a motion in asking for the judge by name.
Right.
Now we read, remember when we found the law about reassignments and asking for judges by name, and it was this whole law argument that you cannot ask for your own judge by name. You can reassign it because based on caseload that each judge has, the assignments have to go according to like First we give one to him, then we give one to him, then we give a case to him. You can't, everybody will go in there and get the easy judge if he's sentencing low.
Right. Yeah. And get cases dismissed and dropped. Yeah.
Right. If that was the judge that was doing that. And so they knew that he had already dismissed the case of copyright infringement against me.
Mm-hmm.
So they wanted him again so he could do the same again. So it was them looking for favoritism.
Well, they did that throughout the whole case.
But we had our own judge. Why couldn't Richard Story, being a senior judge, be on the case?
Right. And remember, before they even switch judges, they're going to, what they say? That they put in a motion for us to stop talking, to stop putting in motions so the judge can rule on a summary judgment, something like that. Remember?
Yes, that was a motion to stay.
Yeah.
Yes. So that they wouldn't have to answer discovery, which was the questions we sent to them requesting discovery. And we were like, you get 30 days according to the law to answer these discovery questions.
Right.
And they had not answered, and we asked for a motion to compel. We said, here's a motion to compel you to answer our discovery questions.
Exactly.
And they didn't want to answer. So they put in the 87, document 87 and document 89.
But they didn't want to give us no discovery.
No. We had all the documents we needed to prove our predicate acts. We didn't need discovery to prove that. We just wanted Tyler Perry to answer some of our questions.
Right.
Remember those questions?
Yeah. And open.
We wanted them to answer the questions about who writes their scripts, if they write them themselves.
Yeah, because remember, we had found out that Tyler Perry was being sued by his writers once before. Remember?
I remember you said you read that and you sent it to me.
Yeah, it was. I think it was 3 or 4 writers that sued Tyler Perry because he had promised them I think it was. I'm not sure what he promised them, but he promised them more money. You know.
So, but they were writers. I thought he writes everything.
Right, and I think he promised them a piece of one of the sitcoms he had out. You know, but they never got it because I think the Writers Guild was suing too on behalf of the writers.
Because they probably registered with them.
Yeah. Mm-hmm.
We found a lot of different cases like that.
It was a total disaster for him on those cases because it made me see exactly who he was. You know, I'm not gonna say that he's a totally bad guy, but I will say he's deep. He like to steal.
Right. Unfair.
Right. He's unfair. He because all they had to do was just offer a little something. You know, especially for your work and my work, we weren't asking for a lot of money. We were just asking for credit, maybe. You know, credited. Which
would have helped us get other jobs as writers and helped establish us. But instead, the way he went about it got us blacklisted.
Right. Now, they said that I ended my career before it started. TMZ told me that. He said, oh, we ended this career before we started by suing Tyler Perry. And I'm like, wow, how did that happen?
That's industry people. They know how this industry works. That's why when we were in our case and we came across that article for Monique, we was like, oh my God, here we go.
Well, I was supposed to just let them have it. Say, forget about it, go on, man. Go on, take that.
And then nobody would know who you are. And you can't even prove that's your work. And you can't even get new work off of that work.
Right.
Right. We could have took credit without pay. For a new writer, that's big time.
But he had already said that he already wrote it and directed himself.
Yeah.
So he couldn't go back on his word to the public. But he could have did that up under the table and said, "Here, you go some money."
Well, then keep it. Keep it and say you wrote it, and let me be your ghostwriter, and go ahead and give me something for it.
I would have did that.
Yes. I mean, I would have been happy with just $100,000, $300,000, something small as a writer. And it made all these millions or hundreds of millions or, tens of millions.
Right.
It's like he picks and chooses who he likes enough to give credit to. You notice that?
Well, this is how I see it.
Mm-hmm.
If you're already in the industry, right,
Mm-hmm.
and you're a writer, and you already have movies already out, it's kind of a little bit hard to take his stuff versus taking mine, because I'm a nobody.
Right.
See, I'm an up and coming writer.
Mm-hmm.
So he could take mine and knowing I don't have money to fight it versus taking somebody else's, knowing they can grab a good attorney. But they go back to the hood and steal. They don't steal from people at the top.
Well, we learned why, right?
Yeah.
We learned how expensive these cases are. We learned firsthand that no wonder when we get mad that we ask a lawyer to take our cases on contingency and say get paid later. With the way they play the game, they know that something's going to come up to where they're not going to be able to collect their money in the long run, because there's going to be the same things that we had happen in our first cases is going to happen like it happened to us in this case together, where they do Jimmy Mickey this, Jimmy Mickey that, contact the clerks, have the clerks hazing us and putting wrong information, removing laws out of our thing. What can a regular lawyer do with the clerk doing that, or whoever in the court is doing that? Right.
And then sending out our motions to wrong case numbers and all kind of things like that. It's just ridiculous how the court system is.
And you know how much money it costs us?
Yeah.
Because then we have to ask to do a motion to correct the motion that we go on there, pull it down from Pacer. We're looking at it. We're scrolling through. We're like, this is not what we wrote. Where's the laws? Where's the appendix? Where's the information that we know that we submitted in there? Because we got a stamped copy of what we sent out. And the stuff that, how we busted them? We busted them because when you open up their argument to our document, they're not arguing from the electronic copy. They're arguing from the paper copy we sent them in the mail, because they're making arguments about stuff that's missing from the one that's filed electronically.
Right. Exactly.
Right. Okay, well, it was there because they're talking about it and we don't see it there no more, but they certainly talking about it.
Like the judge. They arguing about the judge being defended,
and a co-conspirator.
When you open the document, it's not even there.
It's
not the person went into the document and took the stuff out of it. Yeah.
How does a lawyer accept that for payment?
Right.
So rich people can afford to give a lawyer a lot of money to do what we did. Right. Due diligence, going back into the record, babysitting what gets put on the record, or when we file it, making sure nobody goes into the file, pulling it down, editing it in the PDF Word or whatever, putting it back on the record, talking about modified. We got almost so many documents modified on the record. It's not even funny.
Right.
And if it wasn't us telling them to modify it, it was modified without our even knowledge.
Right. Just like we was going over yesterday.
Document 85.
Look, if you file documents 81, 82, 83, 84, 85, 86, 87, 88, then when you look at the docket sheet, it says 81, 82, 83, 84, 85, 86, 88, 87, because they went back into the docket sheet and changed it, modified it, so they couldn't get that spot back. So it's got to go above 88, not 87.
And the dates are switched.
Right, and the dates are
Document 87 is on a document that is later and
Right.
88 is on an earlier date.
Right.
How
And
you
then,
got 88 on the 5th and
Right.
87 on the 6th?
right. And then remember when they stamped over the whole document, put a stamp over the whole
Double
document?
stamped, yep.
Double stamp. This is what we was going.
So you're talking about
Right.
document 170. Let's be clear on that.
Right.
Document
We
70.
gonna show them.
170. We're gonna talk a little bit about that because that was a serious offense. While we were sitting in the appeals court, the defendants put more information on the record. When they did that, we were like, wait, hold up. Then you just right here on the record, we not allowed to put nothing else on the record.
Right.
Oh, we not allowed to.
No, he said this is what the judge.
Just us wasn't allowed.
Right. We weren't allowed to. And the judge actually said, he said, I have no more jurisdiction over this case.
In his yep.
In his
On the second appeal,
on the-
1714866.
he said he has no more jurisdiction over this case, but he can go back into the record and put something back on the record and don't tell us.
And they can put something on the record.
Yeah, they did. They put 2 motions on the record.
Yeah, the summary judgment and the writ.
Right.
Yep.
And the
And we're
Lord
like,
put now, not
But you
in the
just
appeals
told the
court.
appeals court on your answer to the jurisdictional question that they had the jurisdiction.
Right.
So if they have the jurisdiction, nothing else should be going on down there. Once you hand the jurisdiction over on a final set of orders, nothing else should be going on down there.
Right.
So do you
What-
believe they put it on there July 5th, 2018, right?
Yep. Yep.
The summary judgment document 157, 158.
Right.
On July 6th, in the appeals court, the judge put his answer to the jurisdictional question saying, the record is complete. Now, he's not talking about July 5th, the day before.
Right.
He's talking about what we filed an appeal on was document 143 and all the way to document 1.
Right.
157 did not exist. 158 did not exist.
No.
But he starts talking about it in his jurisdictional question.
But it don't supposed to exist.
It don't exist at the time, but he was talking to the tune of their summary judgment. But he
Right.
knew he was talking about their first summary judgment that was filed
See, that's the thing. See, he
in
was talking
June of
about it.
2017, huh?
He was talking about it like he had already, like it was already on the record, and it wasn't on the record. So he was covering himself. So now he had them to go back into the record and put something on the record, and he put something on the record because he already talked about it.
Right.
That, now you know what they call that, right? Cheating.
It's called fraud upon the court.
Fraud
From what
upon
we
the court.
learned, fraud upon the court is conducted by an officer of the court when they defraud the court itself
By one of the chief officers.
under Rule 60,
Yes. Yeah.
Federal Rules Civil Procedure 60.
And everybody knows you don't get 2 summary judgments on one case.
So, yeah, you don't get 2 summary judgments. And so we're sitting here like, okay, they want to play this game. We're going to go ahead and amend our appeal.
Right.
Remember?
Right, but you know another trick that they pulled?
What?
They said that you filed 2 cases of RICO and I filed 2 cases of copyright infringement.
Oh, on document 138, which his orders.
Yeah.
His orders.
So they could rule on both of them. Now, how can me and you doing the same case but filing different cases on the same case? You get what I'm saying?
Makes sense. So here they're saying, I filed two prior civil RICO cases.
Right.
And we're gonna go through the documents because look, my last case with Tyler Perry was copyright infringement, right?
Right.
It was collaterally estopped because the one before that was copyright infringement.
Right. Right.
You can't have a collateral estoppel if it's
But
not
he
the
tried
same
to-
case.
But he tried to use that collateral stop in this case.
And he used collateral estoppel saying that I had 2 prior civil RICOs, and now this 3rd civil RICO is collaterally estopped and
It's
registered.
already collaterally estopped.
Right. But then at the same time, you and I both had copyright infringement cases.
Right.
So doesn't that mean you should have been allowed to proceed? But the truth is, you can't change what the past cases was. They wasn't civil RICO.
Right.
But you should have been able to proceed.
Exactly.
So it was all fake. It was smoke and mirrors. It was lies.
All of it was lies. You know, anytime you get a corrupt judge on the case with people that have millions of dollars, what do you think was gonna happen? The case was gonna get corrupted either way it went. But I told you that though. I don't know if you remember. I said, if they switch judges, Terry, we're gonna be done.
And this happened before they switched judges too.
Yeah. Yep. And then when they switched judges, you said, oh, don't worry about it. He might do the right thing. He might be right. I said, no, he ain't. Because we already looked him up. When we picked up the Judge Thrash.
I was trying to keep the hope alive. We had invested so much money in fighting this case.
Yeah, we did.
And we, you know what? I thought, I ain't gonna say what we thought. I thought because our last cases, we were done just as wrong, that pointing that out in this case and making that the reason why we brought the RICO case would straighten that judge out and make him act right. You know what I mean?
Right.
Like, oh, this is about their case now is about the corruption.
Right.
And how y'all won those last cases. It's not about the copyright infringement. They ain't even talking about, they ain't talking about no book, no movie, no screenplay. They're not talking about no lovers killed. They're not talking about no bad apples getting good.
We ain't talking about none of that.
No. And so I'm thinking no judge in his right mind would try and do the same corruption that we lined up, that you're in Indiana, I was in the Southern District of New York. These are 2 unrelated district court judges doing the same tactics, and the lawyers are doing the same tactics and getting away with it with these judges. So if we point this out to the judge, it's not going to happen to us a 3rd time or a 2nd time for you. No way in the world. They'll be afraid to get exposed about what they're doing. That's what I believe.
That's why they kept us out of the public. That's why they kept us out of the media, because they didn't want this case to be in the media because they knew it was a shambles. And that's why we're putting it out there now, so everybody can see what actually really happened. Right?
Yes. We tried to get the media involved. They wouldn't touch it.
No, they wouldn't. They wouldn't even take our calls.
Not at all.
You know?
It was as if someone reached them before we did.
Right.
And it was as if we didn't exist. And I think another problem, and I'm not defending the media, the fact is that we're not attorneys. And they're afraid that somehow they would have been liable if we said something in the media that wasn't true.
Right, but you know what? If we were attorneys, they would have probably threatened us anyway, like they did the prior attorneys.
Right.
You know?
And that's another reason why we filed that.
That's why we did it ourselves, because we couldn't trust no attorney to even bring it to them. You know? That's exactly why we did it. Because,
and then we felt like we were in over our head a little bit, and we contacted a few attorneys.
Mm-hmm.
Do you remember that?
Yeah, that's because we weren't too familiar with the law.
And we saw them violating the law. We're like, whoa, something we don't know?
Right.
We missing something we're reading here. You can't do that.
Because we was busting their head when it came to the law. And you know one thing I noticed about this whole case?
What?
This is my opinion.
Okay.
My opinion is they don't even know how to fight cases in the courts, in the court system.
You're talking about the lawyers, right?
Right. They don't know how to fight those cases.
We've talked about that, yes.
And the reason why they don't know how to fight them is because they never had to go this far. That's why everybody always end up settled. Now, once you get deep into the case and then you got to go to trial, don't nobody want to go to trial, especially in the RICO case.
They always win on these motions to dismiss.
Right.
They always win on these. They take and they create these summary judgments and all of this confusion and make the courts not even want to touch the case.
Right. Well, the courts have no choice, but the judges always put them in. Oh no, you said better than me.
Summary judgment and let them. Default when they let them.
No. They always say you got to go into a meeting to discuss settlement.
Mediation and stuff. Yeah, mediation, settlement. You know what? We knew if they was going to schedule mediation, we read, normally that means you have a lot of issues that they can't win on, and you're winning. Right. And it's given the opportunity for the other party to go ahead and settle out.